Good morning and welcome to the ParkBridge Wealth Management Spring Webinar Series. This program is entitled Designing Resilient Estate Plans, Planning to Avoid Litigation. As always, my name is Jonathan Shenkman. I'm the President and Chief Investment Officer of ParkBridge Wealth Management. In that role, I serve in a fiduciary capacity to help my clients achieve their financial objectives. The goal of my programs is to bring professionals together to help them better serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between a client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not for profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 20 or so events I run every year, I also do a fair amount of writing on the topics of investing and financial planning. And you can read my work in a variety of periodicals, including Barron, CNBC, Forbes, Kiplinger, The Wall Street Journal, and Trust and Estates Magazine, to name just a few. You can see all my work on my website at parkbridgewealth.com/articles or by following me on social media at Jonathan on Money. Additionally, you could check out my weekly podcast, which is also called Jonathan on Money, and you can listen to that on Apple, Spotify, or wherever you get your podcasts. And finally, I've published my first book, D's for Diversification, The ABCs of Personal Finance, which can now be purchased on Amazon or at jonathanonmoney.com. It's a great way to support these programs. Today, we're privileged to hear from Asher Lowenstein, founder of Lowenstein Legal PLLC based in Long Island, New York. By way of background, Asher is an estate planning attorney with nearly a decade of experience helping families navigate planning and dispute resolution. Known for his clarity and attention to detail, he explains complex issues in plain language and structures plans that prevent conflict and protect family goals. A Harvard Law graduate, he trained at Simpson Thacher, clerked at Southern District of New York, and later worked at both international boutique firms handling sophisticated disputes. His background, combined with a client-centered approach, allows him to offer skilled practical counsel attuned to the sensitive nature of family, legacy, and long-term planning. And today, Asher is going to be speaking on designing resilient estate plans, planning to avoid litigation. And with that introduction, I'll now turn the program over to Asher.
Thank you so much, Jonathan, for that kind introduction. Good morning, everyone, and thank you for joining. My name is Asher Lowenstein. I want to thank Jonathan and ParkBridge Wealth Management for organizing this talk. My practices, as Jonathan mentioned, focuses on trusts and estates planning, but I also spend a significant portion of my time on litigation that follows when a plan fails. So that gives me a view of what goes wrong and sometimes what can be done to prevent it. So over the next few minutes, I want to share some of those things those failures have in common and how strategic planning can really help to reduce the risk of litigation. So this talk is organized in 8 short sections. We're going to start with the 2 doctrines that drive most contests. A will, whether it's a will or a trust contest, that's capacity and undue influence. From there, we'll move on to drafting, distribution standards. Often language that seems clear at signing can produce, long litigation. And then on to 2 structural problems. So these are blended families, business succession. Sometimes these are the plans, that the structure itself that is in place creates the conflict. And then we'll close briefly with valuation and trustee selection, which seem as administrative decisions, but they're really also often at the heart of a dispute. I should just note that while I practice in New York and New Jersey, the considerations that we're going to be discussing apply generally across all jurisdictions in the United States. So that's why I drew cases from several states. The legal standards may be different in various respects, but the underlying concerns really are the same across the states. So I want to start with the stakes of an estate contest, because often doctrine alone does not move people. But there's so many examples to choose from, but let me just start with one. And that would be James Brown, the godfather of soul. Not because he's necessarily the best example, but it's just an illustration. So he died on December 5th, 2006. His estate included a trust meant to fund scholarships for needy children. It was in litigation for nearly 15 years and finally settled in July 2021. That's 15 years. Every year, the estate was drained by fees, frozen distributions, and every year, the beneficiaries waited. That scholarship fund that he wanted so much sat untouched while the lawyers argued about it in court. And every professional in his orbit, advisors, trustees, anyone connected to that estate, for them, those 15 years meant depositions, document productions, testimony about meetings that had happened, many years before that. Everybody understands this, but it just, when you see an example that sort of brings it home, nobody wants to have to go through this. And that's what we're hoping to avoid. So let's start with the first question that comes up in virtually every estate contest, because it's generally elderly people who commission and amend their estate planning documents. The question is whether they had the capacity to do so. So what is testamentary capacity? It's a legal threshold, and it's not much of a threshold. The standard is pretty easy to meet. And the standard is the testator, the person producing the will or a settlor in a trust, must understand the nature of the property, the beneficiaries, that means the people who, the term is the natural objects of the bounty, and the plan. So that's pretty simple to meet. Understand the property, who's getting it, and the plan. It's a pretty low threshold. And this case I cited here in the bottom of the slide, the Georgia case, Wilson v. Lane, it illustrates this really vividly. In that case, the testatrix, the woman, had this irrational fear of flooding in her home. She called the fire department once to report a fire that did not exist. And somebody involved in her life challenged her will. The court upheld her will. The court said, and here I quote, "Eccentric habits and absurd beliefs do not establish testamentary incapacity." So it's not that hard to meet the standard. And for the same reason, someone diagnosed with mental illness is not necessarily disqualified. And the standard looks at whether there are lucid intervals. Are there periods of lucidity between those periods of incapacity? And if that is the case, then during those intervals, the testator is presumed to have capacity and to be able to devise as he or she desires. I should just mention that there is a higher bar with respect to irrevocable trusts. And that's because, unlike a will, an irrevocable trust takes effect immediately and is really a gift of sorts. And in the case of irrevocable trusts, the donor also has to understand the effect of the transfer on his or her own financial security. So that's something that could add some complexity, especially in sophisticated estates, involving multiple trust structures. That distinction is worth keeping in mind. So given that low threshold, we might think that capacity is easy to establish, but in practice, it is frequently litigated. And we want to think about ways to set up a record that their capacity was in place, there was testamentary capacity when the settlor or the testator produced that will or trust. And the best way to do this is to build this persuasive record. Things like taking contemporaneous notes, detailed notes that document the client's awareness throughout the process. In a will contest, the drafting attorney's file is often the most important piece of evidence in the case. And the client's own words on the day of execution can win contests more than all sorts of fancy evidence might. So sometimes the file is not enough, particularly when you have a beneficiary being disinherited, and that should be the signal that this is going to be more complicated and there's more precautions have to be taken into consideration. These situations call for more. So if you can get a medical or a psychiatric evaluation before somebody executes, the document, that's the strongest record you can create. It obviously has to be done properly, and you have to keep that written report of the evaluation in the file. Some people like to use video recordings, and it can be an important tool, but you have to be careful with a recording of the individual at the time that he or she is executing the will or trust. They can explain what they're doing and why on the video, and that can be very helpful, especially when the client presents well on camera. On the other hand, a video can also be used to show that the testator lacked capacity. And if a recording does not go well, then the question arises, what do you do with that video? And I would just caution that you should get guidance before you decide to do anything with it, because in litigation, the opposing party can get discovery into your process, and they might uncover that the video existed and was destroyed, which in itself can create an inference of incapacity, which possibly worse than the video itself would have caused. So other options that some people suggest include a clause in the instrument. So in the will or the trust, you can have a clause there that says that there are no amendments to this instrument are allowed without getting medical sign-off. And that could be effective. That's nice. It might not be effective if the testator or settler goes ahead and amends anyway. And whether that would invalidate the amendment is not so clear. That would itself be something to litigate about. But at least it does create when the testator follows the instructions, it creates a procedural record that is very useful. And more generally, we want to consider when somebody becomes incapacitated, perhaps they should be moved off their fiduciary duties before any issues come up. Okay, this brings us to undue influence. The second doctrine that comes up in nearly every contest is generally, this is the most successful line of attack. And this is, the quote in the slide comes from a prominent case book. They call it an unruly concept because it just doesn't behave like you would expect the concept to work. And unlike capacity, which is a relatively bright line, you can build a record around it, undue influence is much harder to defend against. The test is a qualitative test, and the evidence is almost always entirely circumstantial. The influencer is alone with the testator. The testator is not here anymore, or the settler. The court has to infer what happened. So this is why so much of what we do on the planning side carries so much of the work that will eventually play into the question of undue influence. So what do courts look for? This is these four elements are generally what courts will look for. The first thing is, so this is what tells us that you have an undue influence problem. First is whether there's susceptibility to influence, and that could just mean somebody who's elderly, somebody who's reliant on someone. Is there an opportunity to exert? That means the individual who's benefiting from a change or from in a will or in a trust, or somebody who somehow gained from, or if it's an original trust that's created for that person's benefit, has the opportunity. So they're around, they spend time with the testator or settler. And is there a result that does in fact benefit that person? This is not difficult to show. This is not rare, where you have somebody in this position with the opportunity to exert influence on somebody who is susceptible to it and does something that helps them. So beyond the elements, courts often will find that if there's a confidential relationship together with suspicious circumstances, okay, what are suspicious circumstances? That could be something as simple as changing the trust to benefit the person in question, the beneficiary, more than he or she would have received otherwise. And that can even shift the burden to the party supporting the will. And that might even be possible for them to support, to prove that the will was above board. And the casebook illustration here is this case cited from Mississippi. In that case, a woman named Fannie Moses, she was widowed 3 times. She left nearly her entire estate to a lawyer who was both her attorney and her lover. He was 15 years younger than her. But he got an independent attorney to draft the will, and it was really questionable whether there was anything suspicious at all. Okay, it's quite likely she just wanted to leave her estate to him. No one disputed her capacity, yet the court struck down the will because there was a confidential relationship here. The court found all those elements: susceptibility, opportunity, disposition, and so that's why it's a helpful case. It walks through all of these elements, and that just shows you that it can be a very difficult doctrine to have to deal with when litigation comes up, and that's why you want to take steps to set up the record properly. And here, this is just the two concepts side by side. We have capacity, and it's a pretty low threshold, and then susceptibility generally would apply when you have somebody who's somewhat elderly. So what are the warning signs? Warning signs, these are things we should be aware of. When you see them, this means you have to start paying more attention and perhaps taking other steps. So a beneficiary arranged the engagement. It was present at the execution. Okay, so who called the lawyer? Who called the financial planner to discuss changes to the trust? Was that a beneficiary? Was that maybe a grandchild? Well, that could be a problem. Instructions should come from the individual himself, who was the settlor or the executor. Another warning sign is when there's a significant departure from a prior iteration of that will or trust, or somebody who's a caregiver, a companion, suddenly becomes a substantial beneficiary. So none of these factors is necessarily disqualifying, but the more elements that are present, the more difficult it becomes to prove that everything was done properly and that there was no undue influence. So what do? We want to control the process. So what that means practically is we want to make sure that there are private meetings with the testator or settlor at every stage, not just the first. Sometimes if somebody else gets involved, we have that caretaker, that grandchild who gets involved, maybe we need to reset the engagement, okay, and just go back to the beginning and say, let's start this process over. Another thing that some people get caught up on is it's really important to send drafts of any documents to the client, send them to the client, not to somebody else. A lot of planners are reluctant to send documents because they're concerned that the client will execute them independently and won't pay them. And that's an understandable concern, but it's really important to create a record that can be upheld later. And you want to send this document, this draft with a cover letter summarizing the provisions. That gives the client a real opportunity to review everything, and it closes off the argument that the individual, the settlor, did not know what was in the documents. You want to generally use independent witnesses, not friends, and obviously you want an affidavit at execution. Get as much testimony from the witnesses as you can. And finally, just there is some misperception about whether a trust, a revocable trust, would changes the consideration at all. And it doesn't really, because the same problems with capacity and undue influence apply to revocable trust, to any trust, except there's one slight difference, and that is because the trust shifts the procedure onto the contestant when it comes to a will. So all you have to do is object. You come to court and you say, I object to this will. With a revocable trust, you actually have to initiate some kind of proceeding and bring up the issues that you believe that the contestant believes are with the will or trust. So there are some other ideas that people have suggested, and here are some of them collected here. One effective way, I don't know if it's the most effective one, but some people have suggested executing several iterations of the same will or trust, or essentially the same one, over time, over several years, because if somebody has expressed the same intent across several iterations, it's really harder to attack that than the one that appears right before they die. Another approach is to give lifetime gifts consistent with the testamentary plan, because then the client's conduct during life corroborates the documented intent. Some practitioners, when they have a client who comes to them and say they want to disinherit a beneficiary or give them significantly less, they will require that client to write a handwritten statement of what they want to do. And sometimes in high-risk situations, you want to get independent counsel, that someone is completely separate from any beneficiary to remove any doubts about the testator's intent. And a lot of these elements tend to appear together. So one of the well-known example, this had to do with the estate of Brooke Astor. In that case, her son arranged for the attorney to come and draft up the will. She was isolated from, lots of her longtime friends. And this late amendment redirected about $60 million away from charitable institutions that she had planned to give to. And this was while the testator had Alzheimer's. And so you can see there's a lot of elements that didn't look, a lot of issues here with this will. And the point is that a lot of them come up together, a lot of the factors that could be used to disqualify an amendment, as it actually did happen here. And there were professionals around her. They were positioned to notice these signals and ask questions. And that's what we want to think about when these patterns come up. Another important thing is we want to explain disinheritance or unequal treatment. One of the things to do is to explain somewhere. There can be a letter of explanation. There can be a memo in the file. There can be some kind of explanation in the trust document, but it has to be a really specific explanation. There's a phrase that lots of wills use, that they say, I'm giving less to my son for reasons known to my son, or I'm disinheriting him. And most of the time, the son turns around and says, I have no idea what my parent was talking about. So that phrase really doesn't close anything. And in fact, it invites the contest that we were trying to prevent. One of these, famously, there was an estate of Leona Helmsley, who left $12 million for her dog. His name was Trouble. She disinherited two of her grandchildren. And she wrote, the trust said, for reasons that are known to them. That was the only explanation given. And those grandchildren challenged it, and they ended up, the court did reallocate some of the funds to them. And a counterexample to this is the case cited at the slide from Texas. A woman disinherited the children of a deceased son, and her will recited the specific reasons, said that branch of the family had been distant and hadn't visited her. So even though there were suspicious circumstances, including who drafted the will and who the beneficiaries were, the court said that her explanation made sense and that will was upheld. Okay, so let's move on to another topic, and this has to do with precision in drafting. Many disputes begin with language that might seem clear to the people who are drafting the documents, might say things like equal shares for support, to maintain a lifestyle. Those phrases might sound a little different a few years down the road, differently than they sounded at execution. And just a couple of examples. This is the first one. Well, let me just mention this one from Robin Williams' estate. He had a widow, and when he died, widow and 3 children from a prior marriage. And they litigated for a long time over the contents of the family home. And that fight was literally over 3 terms: memorabilia, collectibles, and knickknacks. What did those terms mean, and who did they go to? So if they had spent time defining what they meant by those terms, they could have avoided perhaps that long-drawn fight. And that's just important to really be precise about what we mean, especially in those situations where we think there might be a contest, there might be challenges to the plan. Okay, another related issue on the topic of precision And this is where standards are used. So we're familiar, many of us are familiar with the HEMS standard. That's health, education, maintenance, and support. It's well understood. This is great standard. The IRS recognizes it as an ascertainable standard, but it still generates disputes. What exactly does the support cover? And different trustees might have different answers. And some people use even looser standards, things like comfort, happiness, or best interests, which those terms I should mention are not recognized by the IRS. So instead of these terms, instead of just using loose terms, which could generate disputes, if we believe that there's a chance for challenges and disputes, we might want to use terms that we might use a plan that involves fixed amounts or formulas, that providing based on a formula or fixed amount that spells out exactly what the beneficiaries are supposed to get. And finally, I think this is the final bullet, I think, is a very elegant solution. And that is sometimes you can build in a trust protector, or that trust protector doesn't have to be somebody out there. It can be the law firm that helped draft the documents. And that could be a provision in the trust that if there's any ambiguous language, the trust protector, which may be the law firm, can come in and clean up the language. They can amend it to say what they believe it should say. And anyone who's gone through litigation over contract interpretation, I think, would appreciate the ability to have someone come up and clean up a stray phrase before it turns into a years-long dispute. Here's another problem that comes up, and that has to do with blended families. And it's almost impossible to draft this away, but we should be aware of this. And that's because the surviving spouse and children from a prior marriage often have directly opposed economic interests. So, and I just want to mention, there's a case here at the bottom, a New York case from last year. It's been getting some significant attention. What happened in this case is the husband funded irrevocable trusts, and in a later divorce action, he argued that the assets should not be considered marital property. So there was a question of the assets when they were transferred to the trust, if they were the husband's or they were marital property. And eventually it was set aside, and the court found that the wife got to have an equal share of those assets. But part of the problem was the way he had set up the plan set up what assets did belong to the wife. So that was entirely real estate and investment accounts that had massive unrealized capital gains taxes. So if she had tried to live off those assets, tried to liquidate them for her share to live, she would have faced immediate heavy tax liabilities, and that would shrink her actual payout. And in fact, she would have been evicted from her homes. So part of the consideration here is, I don't know what would have worked under those circumstances. Maybe the wife would have challenged it regardless of the plan. But the fairer the plan is, so we're not putting her in this terrible situation, that becomes much easier to defend. And this is a very common pattern that people try to cut out completely a former spouse or a stepchild, and this is often what leads to litigation. This is something that I see fairly often, and you have families who own a business. They want to leave their business to their children equally. And often equal shares in a business is not the right approach, because what tends to happen is you have some of the children involved in the business and others are not. And the ones who are not involved in the business want to cash out. So what people should consider in advance is preparing insurance, sort of with an estate equalization plan, an insurance that can solve for these problems and allow the children who are only passively invested to cash out, to get their share, and to allow the business to continue. Okay, here's what we have. There's the insurance equalization, estate equalization insurance. Okay, this is another area of valuation where some other plans, otherwise sound plans, can get unwound. And this has to do sometimes the trustee might have too much discretion to decide value. And instead of giving the trustee unbounded discretion, maybe it's better to build in specific requirements of how to go about and get an independent evaluation. This is trustee it's a choice that is very often underestimated. People by default choose a family member, and these are can be are great, can be great, the best trustees in some cases, but they also carry some liability exposure because there's conflict of interest questions. And if there is something that a concern that there will be disputes, then it's really important to consider at least having an independent trustee in place instead of a family member. And the trustee should have, in those cases, rather than giving the trustee full discretion on how to invest and what to do, again, consider limiting the trustee's discretion because that could avoid disputes down the road. And finally, I want to just mention that the financial professionals play an important role, and it might be the cognitive decline that becomes apparent at a meeting, or there's a sudden new companion at a brokerage account, or there's a rushed change of plan when the client is sick. So financial professionals are often the first to see the signals, and they are frequently called as witnesses, and sometimes they can even be defendants. So the financial professionals have an important role here. And here's a summary of these topics we just spoke. It looks like we're out of time now. So thank you very much for your time. My contact information is on the slide. Please feel free to reach out with any questions. And now, Jonathan, let me turn it back to you.
Great. Thank you so much, Asher. If anyone has any specific questions, new business opportunities, or any other issues they'd like to discuss, please feel free to reach out directly to Asher or myself where appropriate. And I'll be sure to also include his contact information in the follow-up email to this program. Just three more quick items before I let you go today. First, my next webinar is on Tuesday, June 9th at 8:30 a.m. on Don't Lean on Me, How to Discharge IRS and New York State Tax Liens, featuring Scott Kestenbaum and Jill Monison from the firm Kestenbaum and Mark LLP based on Long Island, New York. And I'll be sure to send out the invitation to this program in the coming days. In the meantime, if you have a friend or a colleague who'd find these webinars of interest, they can subscribe to my webinar distribution list on my website at parkbridgewealth.com/webinars. Second, you can follow all my work on X and Instagram at Jonathan on Money, and by connecting with me on LinkedIn, you could also listen to my weekly podcast called Jonathan on Money, which is available on Apple, Spotify, or wherever you get your podcast. And you can watch my practical planning videos, which I post several times a week, by following me on YouTube at Jonathan on Money as well. And third, please take 30 seconds to fill out my survey at the end of this program. It helps me improve my webinars and provide timely and interesting content to attendees. I thank you in advance for that. And with that, this concludes today's session. Please stay safe and healthy and have a wonderful day, everybody.